Yeah, this is my video for full sale on terms of use based on Priceline.com for internet law and legal issues. Professor Greg Downey, and it's due today, the 25th. Let's see, the user agreement, terms of, in parentheses, terms of agreement. Priceline.com does meet the qualifications of a legal binding contract as outlined by Steinberger, who says a contract is basically an agreement to do or not to do something, saying a contract is valid means it's legally binding and enforceable. The point of a contract is to clearly outline an agreement so the object is accomplished while preventing disputes or litigation. Any lawyer will tell you that a lawsuit is a very inefficient and expensive way to resolve contract disputes, and it also means you lose control over the issue being disputed since the judge or jury will be making the decisions instead. It's important to know not all contracts have to be in writing. In California, for instance, certain agreements can be oral and still be legally enforceable. Either way, a contract must include the following: parties capable of contracting, consent of the parties, a lawful object, and consideration. Okay, tells us about parties here. Anyone can enter into a contract except minors, certain felons, and people of unsound mind. The contract must identify who the parties are. Usually names are sufficient, but sometimes addresses or titles may be used. In sales agreements, for example, in addition to names, sellers and buyer are sometimes used to describe the parties further. Okay, goes into consent. A valid contract also requires the parties' consent, which must be free, mutual, and communicated to each other. Consent is not free when obtained through duress, meanness, fraud, undue influence, or mistake. Books have been written about the complexities of those factors. Obviously, a person who signs a contract because there's a gun pointed at his head hasn't consented to the agreement and can rescind it. All cases, of course, are not that clear-cut, and the law must apply to each individual case. Also, consent isn't mutual unless the parties agree on the same thing in the same sense. This is often referred to as a meeting of the minds. Generally, there's an offer and an acceptance communicated by the parties. Object. The thing being agreed to is also known as the object or subject. It must be lawful, possible, and defined, and definite. A court, for example, will not enforce a contract to perform an illegal act. Drug deals often go wrong, but a person who pays for drugs that aren't delivered can't seek the help of a court in getting the money back. Consideration. All contracts require consideration, meaning each party must gain something. It may be something that is or isn't done or given. When a party agrees to do something, paint your house, or not to do something, not sell their house to anyone else for 30 days, they must gain something. Generally, if I say I'll paint your house and you haven't promised me anything in return, you can't sue me for not showing up because I haven't received any consideration. Volunteers have been written about this aspect of contracts as well. Certain contracts aren't valid unless in writing. Generally, they deal with real property, certain debts, money exceeding a certain amount, or objects that wouldn't be performed within 1 year within the promiser's lifetime. Naturally, the exceptions can be as broad as the rules. When the agreement doesn't have to be in writing, all other elements of the valid contract still have to be fulfilled. This is what Steinberger had to say in a 2007 article. I want you also to consider the following by Hertzfeld. Have you ever wondered whether online agreements that are not signed in ink are enforceable? How about a website, terms of use, that are available solely via a homepage link that are not explicitly agreed to by users? Are search terms of use legally enforceable against website visitors? In the recent case of Chabad versus Treasulant Corporation, the Second Circuit Court of Appeals provides some important guidance that can be readily applied to the enforceability of website terms of use and other online agreements. I listened to you when he said find something related to the law. I'm going to make a lawsuit. Okay. Listen to the background on the case. The underlying dispute involved a father and son named Shenabel who each signed up online for a program that provides discounts on products and services in consideration of monthly fees. Following Shenabel's enrollment, they received an email from the defendant Tralegiant with additional terms and conditions, including a mandatory arbitration provision. After being charged membership fees for a number of months, the Shenandoahs each canceled their membership and sought a full refund. When Tralegiant refused to provide more than a partial refund, the Shenandoahs commenced a class action lawsuit against Tralegiant, claiming unlawful, unfair, and deceptive practices. Tralegiant responded by seeking to enforce the arbitration provision and its terms and conditions. The district court concluded that the Shenandoahs never agreed to the additional terms and conditions, including the arbitration provision, and the defendant appealed the legal standard. Okay, following prior court decisions regarding contract law and enforceability in the context of shrink wrap and electronic agreements, the email terms and conditions would be binding on the Shenandoahs if the Shenandoahs what do I got here? Let's see, have you ever wondered whether the other agreements that are not signed? Court appeals by some, okay. I just duplicated that, I'm sorry about that. I'll fix it in the deal, but I can't redo this recording. I'm not sure how far I'll get with this. Let's see. Here we go. Okay, following prior court decision regarding contract law and enforceability in the context of shrink wrap and electronic agreements, the email terms and conditions will be binding on the Shenandoahs if the Shenandoahs, one, after receiving actual notice or at a minimum inquiry notice, parentheses, i.e. sufficient information as would cause a reasonable person to inquire further, quote parentheses, regarding the terms. And number two is manifested their assent. And then he says he would consider each of the two requirements in turn. Okay, on notice, okay, on appeal, the Second Circuit stated that the inquiry notice requirement could be fulfilled by factors such as the conspicuousness of the terms or the course of dealing of the parties. For example, courts have deemed the inquiry notice requirement to be satisfied by shrink wrap software license agreements that can only be read and accepted by a license. After breaking the plastic wrap around the product package, since one, the license cannot commence use of the product without being confronted by the conspicuous terms, and two, reasonable licenses recognize that if they did not return the product, they will be legally bound by the license terms. Similarly, in prior cases, inquiry notice was established for certain terms where a party was repeatedly exposed to the terms following a daily download of data, thereby establishing a course of dealing. The key is that there must be actual notice of the terms or sufficient facts or circumstances to cause a reasonable person to make further inquiries. In this case, however, the Second Circuit determined the inquiry notice requirement was not fulfilled because, one, unlike the situation with shrink wrap agreements, the Shenandoahs had no reasonable expectations of receiving after agreement terms via email. The email terms were not sufficiently conspicuous since they were separate in time and space from the parties' prior contract formation, and the Shenandoahs could commence using the service without being confronted by or having to acknowledge the existence of the email terms, and two, unlike the course of dealing case, the Shenandoahs were not repeatedly provided with the terms as part of their ongoing subscription relationship with Tralegiant. Okay, the assent. Section 192 in parentheses of the reinstatement second of contracts and major codification of contract law states assent may be manifested through conduct with or without words or actions, provided that the conduct of a party is not effective as a manifestation of his assent unless he intends to engage in the conduct and knows or has reason to know that the other party may infer from his conduct that he assents. In this case, Tralegiant tried to argue that the Shenandoahs manifested their assent to the arbitration provision through continued membership payments. The Second Circuit disagreed and denied Tralegiant's motion to compel arbitration, stating, acceptance needs not be expressed, but for it is not, there must be evidence that the offeree knew or should have known of the terms and understood that acceptance of the benefit would be construed by the offerer as an agreement to be bound. That is not the case here. The plaintiffs were never put on inquiry notice of the arbitration provision and their continued credit card payments, which were auto-debited from their credit cards, were too passive for any reasonable fact finder to conclude that they manifested a subjective understanding of the existence of the arbitration and other email provisions and an intent to be bound by them in exchange for the continued benefits offered, benefit memberships offered. Now, hold on just a second. What should companies do? Applying the Second Circuit's decision to website terms of use and other online agreements to maximize their likelihood and enforceability, companies should ideally 1. Provide clear and conspicuous notice of all terms. 2. Require counterparties to scroll through to the bottom of the terms and then type in their name in a signature box, click an I agree button, or otherwise expressively and actively manifest their assent to the terms. Prohibit any use of the website or commencement of the relevant services prior to such express and active manifestations of assent. And 4. Periodically have counterparties reconfirm their agreement to the terms. Barring that, at minimum, companies should always provide at least inquiry notice of all terms and require counterparties to manifest assent through action or inaction in a manner that reasonable people would clearly understand to be assent. For example, it may be sufficient to have website terms of use deemed enforceable if the owner clearly, conspicuously, and contemporaneously informs all visitors that by using the website they accept and agree to abide by the terms. However, the Shinabel case makes clear that website terms of use that are available solely via a link in a small font at the bottom of a home page without any notice to users or reasonable manifestations of assent are unlikely to be enforceable. One last point is that even online agreement that follows all of the foregoing guidelines will face enforceability challenges if their terms are objectionable on grounds applicable to contracts in general. Example, adhesion, unconscionability, consumer legislation, public policy, statutes of frauds, and other situations where a written document would be legally required. This is by Hertzfeld in 2013. He was a trial attorney. See, now here, let's see, this is why I summed up here. Visitors and members need to click on I agree, and still the company needs to be very much aware of what Hertzfeld pointed out above. Priceline.com can be sued in similar situations that Hertzfeld points out above. My recommendation is that instead of being redundant, I point out what Hertzfeld said above and would make sure what he suggested is followed as close as possible. This will cut down on misunderstandings. Not only will this help the legal department, but will also increase goodwill with our customer base, help to promote brand goodwill, and last but not least, increase brand awareness. Okay, thank you for listening. I have really enjoyed your class. Thank you.